Welcome, everyone. This is the final class of the July 2025 administration, and we're going to do live MBE questions. Ashley, are you ready to rock and/or roll? Look at that. All right, let's start. I'll put up the polling feature so that y'all can you can participate. All right, let's do the first question. So, what would the attorney's best advice be? A landowner mortgaged her land to a nationally chartered bank as security for a loan. The mortgage provided that the bank could, at its option, declare the entire loan due and payable if all or any part of the land or any interest therein was sold or transferred without the bank's prior written consent. Subsequently, the landowner wanted to sell the land to a neighbor by installment land contract, but the bank refused to consent. The neighbor's credit was good, and all mortgage payments to the bank were fully current. The landowner and the neighbor consulted an attorney about the proposed transaction, their desire to complete it, and the bank's refusal to consent. What would the attorney's best advice be? Even if the landowner transfers to the neighbor by land contract, the bank may accelerate the debt and foreclose if the full amount is not paid. The due on sale clause is void as an illegal restraint on alienation of the fee simple, so they may proceed. By making the transfer in land contract form, the landowner will prevent enforcement of the due on sale clause if the mortgage payments are kept current. The only effect of the due on sale clause is that the proposed transfer will automatically make the neighbor personally liable on the debt, whether or not the neighbor specifically agrees to assume it. It seems that almost everyone's picking the same answer here. All right, perfect. Yeah. I mean, everyone's picking A. You agree, Ashley, that the due on sale clause is valid and it'll allow the bank to accelerate the debt? Perfect. A is correct. The mortgage contains a valid due on sale clause. If the landowner conveys the land without the prior consent of the bank may accelerate the mortgage debt. A sale by use of installment land contract is a transfer of the land which can trigger the due on sale clause. So due on sale clauses means that if the property is sold, they can accelerate the mortgage and demand the entire balance. It's valid, right? As long as it's reasonable. Same with an acceleration clause or a no early prepayment clause or any of these potential clauses on mortgages are bargained for and therefore enforceable. A due on sale clause means that the property is sold, the entire balance of the mortgage will be due. So should the court grant the wife's motion to dismiss? A husband from state A filed a divorce action against his wife, assistant state B, in state A federal court. The husband asked the court to divide the marital estate valued at $2,755,000. The couple lived in state B at all times during the marriage. The wife had never been to state A before the lawsuit was filed. The wife answered the husband's complaint without asserting any affirmative defenses or filing any additional motions. 2 years into the lawsuit, after discovery had been completed, and 4 days before trial, the wife filed a motion to dismiss, asserting that the court lacks subject matter jurisdiction over the husband's claims. Should the court grant the wife's motion to dismiss? No, because her motion to dismiss was not timely. No, because she waived any affirmative defenses when she filed her answer. Yes, because the federal court in state A lacks subject matter jurisdiction. Yes, because the district court in state A lacks personal jurisdiction. For these on test day, I recommend, even if it's an easy looking question, to draw it out, right? If you need a pen, well, you can't take pens. I got hella IBIS prep pens, but draw the V and then draw the parties, write their domiciles and just make sure you get these answers right. So husband from state A, wife from state B. In a divorce action though, right? So most people are picking here. This is a SMJ issue, right? It's not going to be D, state A lacks personal jurisdiction, because the wife had never been to state A before the lawsuit was filed. But what would give them personal jurisdiction in state A federal court? I mean, no one picked D. I think it is. I mean, and it doesn't matter. You can't bring you can't bring D anyway. Even if it was D, like you can't bring that after you've waived it. The only thing you could possibly bring here would be SMJ. And I think that is proper because this is a divorce proceeding. This isn't something that's going to go to federal court. We like C, Ashley? I had to think about that. I was like, I'm not sure they would even have
I
PJ.
think it had to do with the court because
Yeah.
the D says state court and it was in federal court.
Yeah, exactly. I mean, this is a marriage. This is a divorce. This is domestic relations. So the U.S. Supreme Court's held that even when the requirements for diversity of decisions are satisfied, federal courts will not exercise jurisdiction over domestic relations or probate proceedings. Furthermore, lack of SMJ may be asserted at any time and not be waived. Well, D, the answer choice states the correct conclusion with the incorrect legal reasoning. It does appear from the facts that the court lacked PJ. That's what I was saying over the wife originally, but she submitted herself to PJ by answering the husband's complaint. Had the wife wanted to move for dismissal based on PJ, she would have had to do it earlier, right? So I was on that one. I was like, it could have been PJ, but no, it couldn't have. It was way late in the proceedings. SMJ, failure to state a claim for which relief can be granted, and failure to join necessary indispensable party do not need to be brought to first opportunity, whereas the other ones do, or they're waived, including PJ. So really, good job, class. All right, let's try another one. So the plaintiff should recover nothing or something. A man who was driving his car at night stopped the car and went into a nearby tavern for a drink. He left the car standing at the side of the road, projecting 3 feet into the traffic lane. The lights were on. His friend, the plaintiff, was asleep in the back seat. The plaintiff awoke, discovered the situation, and went back to sleep. Before the man returned, the car was hit by an automobile approaching from the rear and driven by the defendant. The plaintiff was injured. The plaintiff sued the defendant and the man jointly to recover the damages he suffered resulting from the accident. The jurisdiction has a pure comparative negligence rule and has abolished the defensive assumption of risk. In respects to other issues, the rules of common law remain in effect. The plaintiff should recover nothing because the plaintiff was more negligent than either the defendant or the man, nothing because the total of the defendant and the man's negligence was not greater than the plaintiff. From the defendant and the man jointly and severally, the amount of damages the plaintiff suffered reduced by the percentage of the total negligence that is attributed to the plaintiff, or from the defendant and the man severally, a percentage of the plaintiff's damages equal to the percentage of fault attributed to each of the defendants. What's up, Rosie? What's up, Rosie? So they told us it's a pure comparative negligence jurisdiction. All right, looks like everyone's picking the same answer here. Well, I jinxed myself. But most people are picking C here, that, yeah, it's pure comparative negligence. So we're going to eliminate A and B. It doesn't matter. Even if you're 90% at fault, you can still recover. And then because they say common law is in effect, I think we assume joint and several liability instead of several liability, right? You agree, Ashley? Nice. C is correct. Pure comparative negligence allows recovery by the plaintiff for all damages not attributed to his own negligence. The plaintiff is therefore entitled to 100% of damages he suffered minus his percentage of the fault. Because it's a joint and several liability jurisdiction, the defendant and man are each liable for the entire award. The plaintiff can collect the full amount of his award from either defendant or both, as long as the total only equals the percentage of damage he entitled to. Can you go back to the question? Did it say it's a joint and several liability district?
No, but I think you just assume because
Yeah, we do just assume. All right, that's what I thought. So look at D. The facts state that other than pure comparative negligence, common law rules remain in effect. The adoption of pure comparative negligence, therefore, did not eliminate the joint and several liability defendants, right? So yeah, you assume that on the MBE, you assume pure comparative negligence and joint and several liability. Nice. All right, the state statute, let's put this poll up. The state statute deprives them, imposes, deprives, or denies. Okay. Small retailers located in a particular state are concerned about the loss of business to certain large retailers located nearby in bordering states. In an effort to deal with this concern, the legislature of the state enacted a statute requiring all manufacturers and wholesalers who sell goods to retailers in the state to do so at prices that are no higher than the lowest prices at which they sell them to retailers in any of the states that border the state. Several manufacturers and wholesalers who are located in states bordering the state and who sell their goods to retailers in those states and in the state bring an action in federal court to challenge the constitutionality of the statute. Which of the following arguments offered by these plaintiffs is likely to be most persuasive in light of the applicable precedent? The state statute deprives them of their property or liberty without due process of the law. The state statute imposes an unreasonable burden on interstate commerce. The state statute deprives them of privilege or immunity of national citizenship, or the state statute denies them of the equal protection of the laws. I think we got 100% of people picking the same answer here. It's usually a good sign. No jinxing. Yeah, I think everyone can agree here that this would be an unreasonable burden on interstate commerce. They gave us so many facts here, like in-state, out-of-state, it was negative implications of the Commerce Clause. It was either discriminating on its face or here unreasonably burdening interstate commerce under the balancing test. So I like B. B is correct. The strongest argument for the manufacturers and wholesalers is that regulating their prices relative to the prices they charge in other states unreasonably burdens interstate commerce. All right, nice. Has anyone gotten every question right so far? Oh, there's a chat. Okay, nice. Well, let's do the next question. So if the jury believes the testimony of defense experts, under what circumstances could the jury properly acquit the woman of murder? A woman charged with murder has entered a plea of not guilty by reason of insanity. At her trial, in which the questions of guilt and insanity are being tried together, the evidence shows that the woman stalked the victim for several hours before following him to an isolated trail where she shot and killed him. Expert witnesses for defense have testified that the woman knew that the killing was illegal and wrong, but that she suffered from a serious mental illness that left her in the grip of a powerful and irresistible compulsion to kill the victim. If the jury believes the testimony of the defense experts, under what circumstances could the jury properly acquit the woman of murder? Only if the jurisdiction follows the McNaughton test for insanity, only if the jurisdiction follows the Model Penal Code test for insanity, if the jurisdiction follows either the McNaughton or the Model Penal Code test for insanity, or even if the jurisdiction has abolished the insanity defense. It's a tough question, but let's think about it. McNaughton means that it's a product of their mental illness, right? They couldn't tell right from wrong. Irresistible impulse means that it was a compulsion, which seemed to happen here. This was an irresistible impulse. So I don't think McNaughton would provide. But the Model Penal Code allows for McNaughton or irresistible impulse. So Model Penal Code will be a proper answer here. But then no, not either McNaughton. It can't be A or C. And then D would just make very little sense at all. So I believe the answer has got to be B, as in basketball. All right.
Sorry, Andrew, can you, why would C not be the answer? And also, because I can't see the questions clearly on the screen or read them. So can you explain?
Yeah. Okay, so can you go back to the question? It just said, when would it be acquittal? And C says either McNaughton or Model Penal Code, but there was no evidence here that the defendant couldn't tell right from wrong and that their actions were a product of their mental illness. There's only evidence that it was an irresistible impulse. So the only way that we could prevail is under the irresistible impulse test.
It also says that she knew that the killing was wrong.
Yeah,
Which-
she literally knew
yeah.
it was wrong. So there's not only is there evidence that doesn't support McNaughton, there's evidence directly against McNaughton. So there's no way in a McNaughton jurisdiction that she could prevail. So you have to eliminate A and C. B is the only possible answer here, right? B is correct. The woman committed murder, and the facts state that the woman knew that killing the victim was wrong, but she suffered from a serious mental illness that made killing the victim irresistible. Although the woman knew what she was doing was wrong, she lacked the ability to control the impulse to kill. As such, a jury could not find the woman to be legally insane under the MPC test because she could not conform her conduct to the requirements of the law. Nice. So yeah, it can only have been a Model Penal Code, or if they would have said irresistible impulse test, but it could not have been McNaughton based on the facts. All right, let's do the next one. So how should a court decide the young woman's motion? Police responded to a call that shots had been heard coming from a certain house. Upon arriving at the house, the police looked through a window and saw a man lying on the living room floor. I always think of that song. The police opened the front door, which was not locked, and found that the man had recently been shot in the back and was unconscious. An ambulance was called. While waiting for the ambulance, one officer walked through the house to see if anyone else was present. No one else was found, but the officer did see on the kitchen table clear bags of what he believed to be cocaine. The officer seized the bags, and laboratory tests later confirmed that the contents were cocaine. After the ambulance arrived a few minutes later and took the man to the hospital, the police went through the house and opened drawers to try to find the gun used in the shooting. No gun was found, but upon opening a drawer in the upstairs bedroom, the police found marijuana and seized it. Later investigation led to charging a young woman who lived in the house with unlawful possession of cocaine and marijuana. The young woman has filed a motion to suppress the use of both as evidence on the ground that the entry into the house and the searches were made without a warrant. How should the court decide the young woman's motion? Granted as to the cocaine, but denied as to the marijuana. Denied as to the cocaine, but granted as to the marijuana. Granted as to both the cocaine and the marijuana, or deny it as to both the cocaine and the marijuana. All right, this one's interesting. I mean, most people think it's B here, right? I tend to agree, but does anyone want to argue why they would pick A or C? Ashley, you think it's B here, right? Because the cocaine is properly seized, right? But they didn't have a warrant to go look for the gun, right? So I think the cocaine was like exigent circumstances, right? There was just a lot of reasons where plain view doctrine, right? We're bringing cocaine in, but the marijuana, I think they came back a few minutes later. It wasn't, instant to arrest. There's just no reason to bring in the marijuana, right?
I agree.
Honestly, it's 2025. I don't think we're too worried about marijuana these days. So the cocaine was properly seized under plain view exception to the warrant requirement, whereas the marijuana was the fruit of an unlawful warrantless search of the home where no exception applied, right? Yeah, pretty solid. Okay. So hey, what I said on the test does not apply. They really do care about marijuana on the test, right? That's like a horrible drug on the test. All right. Is a farmer entitled to a jury trial? A farmer injured by a machine sued the machine's manufacturer on his own behalf and as a representative class of individuals injured by the same model machine during the past 5 years. The farmer alleged that the machine was defectively designed and manufactured because the machine failed to shut off when the key was removed from the ignition. Therefore, the machine subjected its users to a high risk of bodily injury. The suit was brought in federal court and satisfied the requirements for diversity jurisdiction. The farmer sought compensatory damages both for himself and for the members of the class. He timely filed a request for a jury trial on his own behalf and on behalf of the class. Historically, class actions are devices available exclusively in equity. The farmer requested that the court certify the action to proceed as a class action. In response, the machine manufacturer moved to strike the farmer's jury demand. Is the farmer entitled to a jury trial? Yes, on both the issues of the class certification and the underlying merits of the action against the manufacturer. Yes, but only on the underlying merits of the action against the manufacturer. Yes, but only on the issue of class certification. No, on neither the class certification issue nor the underlying merits of the action. Mhm. So most of the class seems to agree here that, we have a federal civil right to jury trials when there's legal relief, for monetary relief, not for equitable relief. And here they did say that class actions are exclusively available in equity. So it doesn't seem that there's any certification of the class action that would require a jury. But they did see compensatory damages for the underlying merits of the action, which compensatory is monetary, would entitle them to a jury trial, so long as this is federal court, not state court, right? It's federal court, right? Yeah, federal court. Yeah, I agree. You like B? It's a tricky little test. Don't believe people when they tell you it's not a tricky test. That's like my biggest beef with the old guard of bar prep is like, there's no tricky question. It's like there's a lot of tricky questions. You got to read very carefully and see. They could have very easily said here, state court, and it would have thrown everything out the window because the Seventh Amendment has not been attributed to the states, right? So you wouldn't have a Seventh Amendment right to a jury trial at a state court. That state may have a statute that provides for a jury, but not Seventh Amendment. So tough concept. I think the way they test the Seventh Amendment is super tough. Right? Because sometimes they'll be like a writ of ejectment. A writ of ejectment actually gets a jury trial. If you learn one thing today, maybe that's will be tested, and you'll be like, man, thank God I called that guy. That's a Billy Madison reference. But like, if you get that writ of ejectment, that actually does get a jury trial because it was given a jury trial at common law. So it's like there's some very rare instances, and they might say in the facts like at before 1791 this received the jury trial. Okay, well then that type of action will get a jury trial, but otherwise it's for legal monetary relief and it's federal claims because it's a federal constitution. All right. So is the witness's testimony admissible? In a suit based on a will, the distribution of 1 million depends upon whether the wife survived her husband when both died in the crash of a small airplane. An applicable statute provides that for purposes of distributing an estate after a common disaster, there's a rebuttable presumption that neither spouse survived the other. A witness has been called to testify as she approached the plane. She heard what she thought was a woman's voice saying, "I'm dying." I don't know why this is funny to me. Although by the time the husband and the wife were removed from the wreckage, they were both dead. Like, yeah, right. You heard someone yell, "I'm dying," and that's going to be the freaking determinative factor. Like, this seems kind of made up, but everything's real on the bar exam, right? So is the witness's testimony admissible? No, because the matter is governed by the presumption that neither spouse survived the other. No, because the witness testimony is too speculative to support a finding. Yes, because the hearsay rule does not apply to statements by decedents and actions that determine rights under will. Yes, because it's relevant and not otherwise prohibited. The answer is D, but the reason why I don't like D is because it's totally bullshit, right? Like, there's no way this really happened. But if it was true, then yeah, it's relevant because it says that she outlived the other, and therefore the presumption is going to be rebutted and la da 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 da. So that's something that you got to get over with the bar exam. They make up a lot of crazy hypothetical scenarios, and you just got to be really, you just have to like suspend reality, suspend belief, and be like, okay, this really happened. Well, then yeah, it's kind of relevant. She outlived the other person, so we bursted the bubble, right? Rebuttable presumption, which has been bursted. Bursting bubbles is cool. Yeah. Okay, cool. Anyone have gotten them all right so far? You can text me privately if you've gotten them all right so far. I want to know who my heavy hitters are. All right, let's try another question. All right, nice. I got 2 people texting me. I should pit them up in a. I'm so weird. Okay, so which of the following is the best argument in favor of the state's efforts to have the lawsuit dismissed? So Congress enacted a federal statute providing that any state may require labeling to show the state or other geographic origin of citrus fruit that is imported into the receiving state. Pursuant to the federal statute, a state that produced large quantities of citrus fruit enacted a law requiring all citrus fruit imported into that state to be stamped with 2-letter postal abbreviations signifying the state of fruit's origin. The law did not impose any such requirement of citrus fruit grown within the state. When adopted the law, the state legislature declared that its purpose was to reduce the risk of infection of local citrus crops by itinerant diseases that have been found to attack citrus fruits. A National Association of Citrus Growers has sued to have the state law declared unconstitutional. The association claims that the law is prohibited by the negative implications of the Commerce Clause of the Constitution. Which of the following is the best argument in favor of the state's effort to have the lawsuit dismissed? I was going to say this isn't a clear cut, but they're saying what would be the best argument. And in fact, they do this in Florida, because when I bought the orange tree that I still have to this day, it's not bearing fruit at the moment. It's not producing at the moment, but there's still hope. When I bought it, there was a tag on it that said that it's illegal to take this out of the state of Florida. And I thought that was potentially a dormant Commerce Clause issue, but it just is interesting. So what's the best argument in favor of the state's effort to have the lawsuit dismissed? Any burden on interstate commerce imposed by a state is outweighed by legitimate state interest. Congress has the authority to authorize specified state regulations that would otherwise be permitted by the negative implication of the Commerce Clause and has done so in this situation. Did it do that? It enacted a federal statute providing that any state may require labeling pursuant to the federal statute. I mean, that's teeing up B as the best argument here. The state does not discriminate against out-of-state citrus growers or producers, or the state law furthers legitimate state interests. The burden imposed on interstate commerce is only incidental, and the state interest cannot be satisfied by other means that are less burdensome to interstate commerce. I mean, I think D is a strong argument, right? Like, because I think that really happens in Florida. But I think here, B is a better argument because it literally said Congress enacted a federal statute that allowed any state to require this. And then pursuant to that statute, the state did that. It's like you were given permission by the boss. That's the express authorization. Do you agree with this, Ashley B? Yeah, I mean, listen, D is not a bad argument, right? Because I think, states rarely succeed in justifying discriminatory commercial regulations, but I think Florida has succeeded in doing that because of what I told you with the orange tree. But here, they gave you a much better, especially on the bar exam, reasoning. And remember, there's two heavily tested exceptions to the Dormant Commerce Clause. This is one of them, when it's expressly authorized by Congress. I always tell students, and I used to have this instructor, Matt Beckerman, who's a freaking genius, and he didn't like this metaphor. I think it was too dumb for him, but it works for me and my cohort of dummies. If you think of, the federal branch of the government as like the principal's office, and then and the principal is literally like the president, the executive branch, and then the state governments, the sovereignties, as like the classes and the teachers. And it's like the teachers have to follow the directions of the principal, the general rules of the school, unless the principal is like, hey, Miss Susie, you're allowed to have cookies today. Like, okay, well then you're expressly authorized by the principal to do something that would otherwise be a violation. Same thing, the states are expressly authorized by, the big dog, the federal government, to do something. So that's the first idea. Hopefully that resonated with some of you. If it did, you're probably a dummy like me, but it's cool to be a dummy. And then the other part is the market participant exception, where if the state is acting as a market participant, they own the oil well or they own the timber or something, then they can also have these types of rules that would otherwise violate the Dormant Commerce Clause. So look for those two answers. And if you see them, lean into them as potentially right answers if the facts align. That's what I say. When there's an answer that you see as a common answer, like, market participant rule or expressly authorized by Congress as exceptions to the Dormant Commerce Clause, don't just automatically pick them. But if you see them and you're like, wait, that's a pretty common answer, would that align with the facts here? Oh, yes. Another one is for evidence, like bias. Oh, well, you see bias as an answer. That's a pretty common answer. Does it align with the fact? Oh, yeah, they are biased. Okay. So it's just kind of like a method that I have. Don't just like pick answers without thinking, right? You gotta think and pick the best answer. But a little strategy that I've incorporated is some answers are more likely than others based on experience. And if you can properly align that answer to the facts, then it may very well be the right answer. All right, let's try another one. All right, some more students are hitting me up saying they got them all right so far. Nice, that makes me happy. My program is doing well. Okay, if the professors challenge the constitutionality of the appropriations provision, is the court likely to uphold the provision? A state university adopted a new regulation prohibiting certain kinds of speech on campus. Students, staff, and faculty convicted by campus tribunals of violating the regulation were subject to penalties that included fines, suspensions, expulsions, and termination of employment. The regulation was widely unpopular, and there was a great deal of public anger directed toward the two tenured professors who drafted and promoted it. The following year, the state legislature approved a severable provision in the appropriations bill for the university, declaring that none of the university's funding could be used to pay the two professors. This statute is targeting those two people who are specifically named in the provision. In the past, the professors' salaries have always been paid from the funds appropriated to the university by the legislator, and the university had no other funds that could be used to pay them. So they're fucked. If the professors challenge the constitutionality of the appropriations provision, is the court likely to uphold the provision? I'm not saying they're fucked and challenge the constitutionality of it. I'm just saying the act of this statute really puts them in a compromised position. They're not going to get paid. So no, because it amounts to an imposition by the legislator of punishment without trial. No, because it was based on the conduct the professors engaged in before it was enacted. Yes, because the 11th Amendment gives the state legislature plenary power to appropriate state funds in the manner that it deems most conducive to the welfare of its people. Yes, because the full faith and credit clause requires the court to enforce the provision strictly according to its terms. I feel like this is the type of question you see on test day, where it's like, what? They didn't really give you the answer here that you wanted. To me, I was like, this seems to be a bill of attainder. So I'm looking for that. A says punishment without trial. Okay, that is technically a bill of attainder. I like A, and that's what most students have picked. The other answer choices, they just are like good answer choices. You know, they would really make you think about it on test day, and you're gonna encounter that. Questions that are just like answer choice, you're like, oh man, that's a good answer choice, but like, does it really apply here? Like the 11th Amendment, plenary power to appropriate state funds in the manner that it deems most conducive to the welfare of its people. Like the 11th Amendment is sovereign immunity. I mean, I'm sorry, sovereign immunity. And I don't think that is really true. Like they have, you know, taxing and spending powers, but there's something off about that. And then D, full faith and credit and requires the court to enforce the provision strictly according to its terms. I mean, they're just trying to throw us off here. Full faith and credit requires states to recognize the judgments of other states. And then A or B, it's based on conduct the profession engaged in before it was enacted. Well, that's an ex post facto, which kind of seems maybe potential here, but this is not a criminal case. So I don't think that could apply either. So I think it's got to be A as a bill of attainder. Hopefully they say bill of attainder in their explanation, right? The challenge provision satisfies the definition of a bill of attainder, right? Like it would have been so much more helpful if they said no, because this is a bill of attainder. But instead, they provided the definition of a bill of attainder, which is a law or legislative action, federal or state, that punishes specifically named individuals or groups for past or future conduct without a trial, right? And then B is incorrect because it's true that the court is likely to strike it down. It's not ex post facto law. It does not apply to laws attaching civil consequences to past conduct, right? That it's only for a criminal penalty for ex post facto. Sometimes it's important to know, you know, differences between civil and criminal and when these things apply. Like, for instance, you can plead the fifth in civil and criminal, but only a presumption can be made in civil, not in criminal. Another example, ex post facto is for criminal, not civil. All right. All right, someone's hit me saying they only missed one. Still going. All right, cool. Let's see. Oh, I have to show y'all Andrea. She passed the MB last time. That's my homie Andrea. She I gotta show you her album. So you guys haven't submitted albums. I'll show you her album. While you guys answer this one, I'll pull up her album cover. Maybe we'll give you some inspiration. Because remember, I'm gonna show album covers at the end of the recording. I'm also going to go over the Cram Guide Points that we created for all subjects. So stay locked in. We're not done yet. So in defending against the prosecution in state trial court, the argument that would be the best defense for the corner store is that the statute violates what? A state statute prohibits any retailer of books, magazines, pictures, or posters from publicly displaying or selling to any person any material that may be harmful to minors because of the violent or sexually explicit nature of its pictorial content. Violation of the statute is a misdemeanor. A corner store displays publicly and sells magazines containing violent and sexually explicit pictures. The owner of this store is prosecuted under the above statute for these actions. In defending against this prosecution in state trial court, the argument that would be the best defense for the corner store is that the state statute violates the First Amendment as incorporated into the 14th Amendment because the statute is excessively vague and overbroad. First Amendment as incorporated into the 14th Amendment because a state may not prohibit the sale of violent or sexually explicit material in the absence of proof that the material is utterly without any redeeming value in the marketplace of ideas. Equal protection of the laws clause because the statute irrationally treats violent and sexually explicit material that's pictorially different from such material that is composed wholly of printed words. And then equal protection of the laws clause because the statute irrationally distinguishes between violent and sexually explicit pictorial material that may harm minors and such material that may harm only adults. All right, everyone's crushing this question. I think you agree, Ashley, with A, right? It's vague and overbroad. All, you know, what's sexually explicit and all that is, you know, who knows? I'm just going to take this commercial break to show you guys Andrea's album cover from last administration because it was definitely interesting. And it has to do with this particular subject. Andrea is super cool too. All my students are super cool. Yep. That easy to find things. All right. I'm gonna replace current share real quick, Ashley. This is Sex is Art. This is by Andrea. So here we go. Sex is Art, First Amendment fuckers, featuring the uncensored. And now you know that sex is art. And this is one of my students from last administration. She put the little ibises, and you see how artful this is. And it just goes to show you that just because something is provocative doesn't mean that it is obscenity. I think that was her takeaway. So how do I stop sharing? Yeah, you can pull up the next one, but that's a kind of idea for your albums. I remember my album was not so provocative, but it's to make you remember things. So that's something you can remember. When is something obscenity? If it lacks literary, artistic, educational value, and it appeals to the prurient interests of humankind, right? Okay, so let's try another one. In the federal civil trial, the plaintiff wishes to establish that in a state court, the defendant had been convicted of fraud, a fact that the defendant denies. Which mode of proof for the conviction is least likely to be permitted? Also, if you're submitting album covers, just know I have the authority to show them in perpetuity. So that's that. In a federal civil trial, the plaintiff wishes to establish that in a state court, a defendant has been convicted of fraud, a fact that the defendant denies. Which mode of proof for the conviction is least likely to be permitted? A certified copy of the judgment of conviction offered as a self-authenticating document, testimony of the plaintiff who was present at the time of the sentence, testimony by a witness to whom the defendant made an oral admission that he had been convicted, judicial notice of the conviction based on the court's telephone call to the clerk of the state court, whom the judge knows personally. You know, it's human nature when you take the test that you want to see the correct answer. So a lot of times, if you don't see it in A, B, or C, you get nervous, and then it appears. But like that's why I tell people, don't just pick an answer and move forward on test day. Make sure you read A, B, C, and D and consider them, because a lot of time D comes in and it's the best answer. And it's like I was sweating this question a little bit. I was like, A, B, and C seem like they'd be permitted. What's wrong with any of them? But then I got to D, and I'm like, yeah, why would they ever let in something that's based on a court's telephone call to the clerk? Like that's just like that is not a reasonable basis for evidence there. So I agree with D, right, Ashley? You hit it with the hezzy. So D is correct. Judicial notice of conviction would be improper because the proof supporting the conviction, the court's hearsay phone call to the state court clerk, is subjective to reasonable dispute, is not generally known in the community or capable of immediate and accurate verification, right? There's no way we're going to let that come in at judicial notice because a clerk called it in, right? No way. Someone said, let's stop soon. They don't want their luck to run out. That's how I feel. But no, I don't. I don't care. Doesn't matter. Nothing can stop you from your purpose. All right, I got a message that said they did not need to see Andrea's album cover. Hey man, I didn't create it. I think it's helpful. You always remember that sex is art. So a cigarette, I remember why. It's because that administration, we were talking about sex as art, and I used to joke around and tell my students that they should go make some art to de-stress. It was like a joke. I've been making jokes for decades now. All right, will a cigarette maker's motion to dismiss the complaint be granted? A cigarette maker created and published a magazine advertisement that featured a person dressed as a race car driver with a helmet on, standing in front of a distinctive race car. In fact, the car looked almost exactly like the very unusually marked car driven by a famous and popular driver. The driver in the ad was not identified and his face was not shown. The cigarette maker published the advertisement without obtaining the famous driver's permission. The famous race car driver sued the cigarette maker for economic loss only based on the common law misappropriation of the right of publicity. The cigarette maker moved to dismiss the complaint. Will the cigarette maker's motion to dismiss the complaint be granted? No, because there's sufficient indicia of the famous driver's identity to support a verdict of liability. Yes, because the driver is a public figure. Yes, because there's no mention of the famous driver's name in the ad. Yes, because the famous driver did not claim any emotional or dignitary loss. I mean, this one, the answer is A. It would be like using the Michael Jordan logo, or like, if you had a golfer with a red shirt and a black hat Nike hat on, like Tiger Woods, you know what I mean? Like there's some people who are, sufficient indicia to know that you are appropriating them for commercial gain, right? So everyone got that one right. We love that. All right. Should the state court issue the injunction? So the childhood home of a former U.S. president is part of a national park located in a city. The National Park Service entered into a contract with an independent antique collector to acquire items owned by the residents of the city during the former president's lifetime. According to the contract, the collector purchases items and then sells them to the Park Service at a price equal to the collector's cost plus a 10% commission. Purchases by antique collectors are ordinarily subject to the sales tax of the state in which the city is located. The collectors filed suit in the state court to enjoin collection of the tax on these purchases for the Park Service, claiming that the sales tax is unconstitutional as applied to them. Should the state court issue the injunction? No, because as the purchaser of the antiques, the collector, rather than the federal government, is liable for the tax. No, because the suit is within the exclusive jurisdiction of the federal courts. Yes, because the federal government is contractually obligated to pay the amount of sales tax when the government covers the collector's cost of the antiques. Yes, because under the Supremacy Clause, the federal program to acquire the antiques preempts the state sales tax on the purchase of these items. Yeah, everyone's rocking with A here too. A is in applesauce. Because, yeah, when they're taxing the contractor or the antique person or someone, they're not taxing the federal government themselves. If they are taxing the federal government themselves, then yes, it would be invalid. But here, they were just taxing someone independent of the federal government, right? Perfect. So which of the following would be most helpful to the state in defending the constitutionality of the statute? A state enacted a statute providing for the closure of the official state records of arrest and prosecution of all persons acquitted of a crime by a court against whom criminal charges were filed and subsequently dropped or dismissed. The purpose of the statute is to protect these persons from further publicity or embarrassment relating to those state proceedings. However, the statute does not prohibit the publication of such information that is in the possession of private persons. A prominent businessman in the state was arrested and charged with rape. Prior to trial, the prosecutor announced that new information indicated that the charges should be dropped. He then dropped the charges without further explanation, and the records relating thereto were closed to the public pursuant to the state statute. The newspaper in the state conducted an investigation to determine why the businessman was not prosecuted, but was refused access to the closed official state records. In an effort to determine whether law enforcement agencies involved were properly doing their duty, the newspaper filed suit against appropriate state officials to force opening the records and to invalidate the statute on constitutional grounds. Which of the following would be the most helpful to the state in defending the constitutionality of the statute? Again, that's why con law does this a lot. I'm not sure 100% what the answer would be here, but they're saying what would be the argument in defending the constitutionality of it? The fact that the statute treats in an identical manner the arrest and prosecution records of all persons who be acquitted of a crime by a court against whom criminal charges were filed and subsequently dropped or dismissed. The argument that the rights of the press are no greater than those citizens generally. The fact that the statute only prohibits public access to these official state records and does not prohibit the publication of information they contain that is in the possession of private persons, and the argument the state may seal official records owned by the state on any basis its legislature chooses. I don't think this is the easiest question. I think there's some potential answers here, but the class seems to mostly be in alignment. Mostly everyone in the class picks C. That's what you pick, Ash? Yeah, C is the best answer here. The court has held that there is generally no First Amendment right of access to records kept by the executive branch. In this case, it is only the access to those records, not censorship of the information that the statute regulates. There's generally no First or 14th Amendment right of access to government-generated or government-controlled records, including those kept by the executive branch. Moreover, the media does not have greater right of access to such documents than the public. All right, this is federal law because my home state, we live in the sunshine. So what are the rights of the investor's friend and the bank in the lot? 5 years ago, an investor who owned a vacant lot in a residential area borrowed $25,000 from a friend and gave the friend a note for $25,000 due in 5 years, secured by a mortgage on the lot. The friend neglected to record the mortgage. The fair market value of the lot was then $25,000. So he borrowed $25,000 and gave him a note. Okay. 3 years later, the investor discovered that the friend had not recorded his mortgage, and in consideration of $50,000, conveyed the lot to a buyer. Snake. The fair market value of the lot was then $50,000. The buyer knew nothing of the friend's mortgage. Okay. 1 month thereafter, the friend discovered the sale to the buyer, recorded his $25,000 mortgage, and notified the buyer that he held a $25,000 mortgage on the lot. Okay. 2 years ago, the buyer needed funds. Although she told her bank of the mortgage claimed by the investor's friend, the bank loaned her $15,000 and she gave the bank a note for $15,000 due in 2 years secured by a mortgage on the lot. The bank promptly recorded the mortgage. At that time, the fair market value of the lot was $75,000. Like, who's doing these credit reports and allowing people to take these mortgages out in this little ass lot? The Recording Act of jurisdiction provides no conveyance or mortgage of real property shall be good against subsequent purchaser for value and without notice unless the same be recorded according to law. So here, look at the recording statute. Does it ever say first to record? No, it just says without notice. So we're in a pure notice jurisdiction. Both notes are now due and both the investor and the buyer have refused to pay. The lot is now worth only $50,000. What are the rights of the investor's friend and the bank in the lot? Both mortgages are enforceable liens and the friend has priority because it recorded first. Both mortgages are enforceable liens, but the bank has priority because the buyer was an innocent purchaser for value. Only the friend's mortgage is enforceable because the bank had actual and constructive notice of the investor's fraud. Only the bank's mortgage is an enforceable lien because the buyer was an innocent purchaser for value. All right, this one takes some time because the first 10 votes are all the way split. So take your time with this one. All right. Let's lock it in. So let's see. I think this is gonna knock some people off of their perfect scores. Okay. So we have people picking B, C, and D. What are anyone's arguments? I'm interested to hear why you guys picked the answers you picked. Why did someone pick B or why did someone pick C or why did someone pick D? Does anyone want to offer any reasoning?
I picked B because all the mortgages are enforceable as liens, but the bank, because it's a it's a purchaser or whatever, purchased for value and had no notice of the other two mortgages. So that's why I thought it was the best.
Okay, fair enough.
Didn't the bank have notice? Because it says she told her bank of the mortgage claimed by the investor's friend. So the bank did know about the friend's mortgage.
Can you highlight that? What do you think you're saying? Although she told the bank of the mortgage claimed by the investor's friend, right?
So the bank did have notice.
The bank did have notice, right? But who'd the bank take from?
The buyer was
The
an
buyer.
innocent purchaser.
Who said that?
Alexa.
I'm rocking with that. What answer did you pick, Alexa?
I picked B because of that, but
Wait.
I'm not sure.
I picked D, and I don't have like a strong reason to back it up other than like
Yeah, I think it's C
I
too.
just didn't think it'd be fair that the buyer took
'Cause-
the
Yeah, I
bought
honestly wasn't
value in the like without any notice of the
It's
more-
under the shelter
I don't
rule.
Exactly.
then
Ashley, go ahead.
Thank you. So under the shelter rule, the BFP is going to take, and then also because of the recording statute at that time, like the buyer knew nothing of the friend's mortgage, and then that was recorded. So they're going to take free of that.
I agree that the BFP will cut off the rights and that anyone after will take shelter in their upstream status. So that's what was leading me towards D as the correct answer, right?
Yeah.
Yeah, only the bank's mortgage. Yeah, I like D here. Let's send it. Nice. This is a tough one. Alexa, I thought you were onto it, but it got.
I honestly was between B and D and just chose one, so.
Yeah, but you had the right reasoning that
Yeah.
the BFP cut off any previous rights and now they take free and clear under the shelter rule. So this was the one that probably got I mean, only 3 people should be left with the perfect score unless you didn't participate. But let's see. D is correct. The friend does not have an enforceable lien. The friend did have a lien on the lot when the investor granted the friend a mortgage. The friend, however, did not record the mortgage. That was not a smart idea. The investor then sold the lot to the buyer. Here we have the BFP. The buyer had no actual knowledge of the mortgage. The buyer had no notice based on possession because the lot was vacant. The buyer had no constructive notice of mortgage because the mortgage to the friend had not been recorded and the buyer received title. The lot is located in notice jurisdiction, right? Thus, the buyer took the lot free of any prior unrecorded interest. So the original party is gone. The buyer was an innocent person of value at the time the buyer received title. Later notice to the buyer and the later recording of the friend's mortgage are irrelevant. So I'll read this extended explanation. At common law, in nearly all cases, priority was given to the grantee who received the property first. However, statutes known as recording acts require a grantee to make some sort of recording so as to give notice to the world that the title to certain property has already been conveyed, to put subsequent grantees or purchasers on notice. Recording the deed is not essential to make it valid, but a grantee could lose out possession, like they did here, to a subsequent bona fide purchaser. Like not recording your deed. I literally kept my deed right in my closet. I mean, in a secret location, right? A subsequent BFP is one who gives valuable consideration and has no notice of a prior instrument. There are 3 types of recording acts: notice, race notice, and race statutes. Under a notice statute, which we had here, a subsequent BFP prevails over a prior grantee who failed to record. The most important factor in notice statute is that the subsequent BFP, who had no actual constructive notice at the time they purchased the property, is going to prevail. Under raise notice statute, a subsequent BFP is protected only if they record before the prior grantee without notice of the prior instrument. This gives an inducement to record quickly to reduce questions of title. Under raise statute, whoever records first and wins an actual notice of a prior grantee is irrelevant. So here, the first step was noticing that this was a pure notice jurisdiction. And then you just want to see who's the bona fide purchaser. Okay, well, the bona fide purchaser was the buyer. Hey, Ashley, did you stop sharing screen for a sec, Ashley?
She's not here anymore. Oh, just kidding.
I don't know what happened. It just like went blank.
Yeah, no, it's all right. It's all right. Glitches. Glitches in the simulation. Okay, so D is correct. In this question's fact pattern, the language of the recording statute is no conveyance or mortgage of real property shall be good against subsequent purchaser for value and without notice unless the same be recorded according to law. The most important words of the statute are without notice, right? Without notice means pure notice. First to record means race. If it says without notice and first to record in the same statute, then it's a race notice. And then if that statute says and judgment creditors are also protected, well, then judgment creditors will be protected too. It's very much reading comprehension, right? So this one was tough though. This signals that this is no statute, so subsequent BFP who records without notice prevails over previous grantee. Generally, the priority of a mortgage is determined by the time it was placed on the property. When a mortgage foreclosed, it'll terminate interest units and mortgage being foreclosed, but will not affect senior interest. Under lien theory, the mortgagee is considered the holder of a security interest only, and the mortgagee is deemed the owner of the land until foreclosure. This is the majority position. The friend had a mortgage for $25,000, but not recorded. The recording act in this question's fact pattern is a notice statute, so subsequent BFP who took without notice prevails over a prior grantee who failed to record. The investor then sold the property to the buyer, who was a BFP, so buyer's going to take, paid consideration, took without notice. Thus, the buyer took free and clear of the $25,000 lien owed to the friend. The buyer then took out a mortgage for $15,000, which the bank immediately recorded. Because the bank recorded, this lien attaches to the property, right? And most people who have picked B here, B is incorrect. As explained above, the recording statute is notice statute, which means a BFP will take free and clear of any mortgage that bought the property without real constructive notice. Thus, the friend's lien will not attach at all, right? So it's all about once the BFP takes in a pure notice jurisdiction, anyone upstream is cooked. And then anyone downstream, they're going to be able to, take mortgages on the property or whatever it may be, as if the BFP had it free and clear because the BFP did have it free and clear. Is it helpful? All right, let's try another. Tough question. If you didn't get it right, just so did most people did. All right. In this action, judgment should be for whom? All right, back to real property. So several years ago, a carpenter purchased Goldacre. A large part of the purchase price. Several years ago, a carpenter purchased Goldacre, financing a large part of the purchase price by a loan from a bank that was secured by a mortgage. The carpenter made the installment payments on the mortgage regularly until last year. Then the carpenter persuaded a friend to buy Goldacre, subject to the mortgage to the bank. They expressly agreed right? Weird. That the friend would not assume and agree to pay the carpenter's debt to the bank. So they expressly agreed that he would not assume and agree to pay the carpenter's debt to the bank. The carpenter's mortgage to the bank contained a due on sale clause stating if mortgagor transfers his or her interest without the written consent of mortgagee first obtained, then a mortgagee's option, the entire principal of the debt secured by the mortgage, shall become immediately due and payable. However, without seeking the bank's consent, the carpenter conveyed Goldacre to the friend, the deed stating in pertinent part, subject to a mortgage to the bank, giving details and recording data. The friend took possession of Goldacre and made several mortgage payments, which the bank accepted. Now, however, neither the friend nor the carpenter has made the last 3 mortgage payments. The bank has brought an appropriate action against the friend for the amount of the delinquent payments. This is going to take a read back by me too, right? So in this action, judgment should be for the friend because she did not assume and agree to pay the carpenter's mortgage debt, the friend because she's not in privy of estate with the bank because the carpenter's deed to the friend violated the due on sale clause, or the bank because the friend is in privy of estate with the bank. Oh, you guys need a poll, right? Sorry. All right, take your time with this one. All right, let's see. There's a little bit of a split here. Yeah, I like A here, right? She did not assume and agree to pay the carpenter's mortgage, so she can't be liable, right? Because now neither the friend nor the carpenters made the last 3 payments. They brought an action against the friend for the amount of the payments. No, only from the carpenter because the carpenter said that the friend would not agree and pay the carpenter's debt. So a lot of people picked, or a few people picked C, that it violated the due on sales clause, but it didn't really matter here. And they still were making payments. Like they didn't exercise their right, and they literally expressly agreed that they would not assume and agree to pay it. So yeah, A is the best answer. A is correct. The express agreement that the friend would not assume liability for the mortgage insulated the friend from liability for the payments, even if she voluntarily paid them for a couple of months. Although the bank may end up foreclosing, its actionable claim against the carpenter for the entire balance of the mortgage, not the friend. So the violation of clause simply gives the bank the right to demand immediate payment from the carpenter, not the friend, right? So like even though they had accepted payments, I was thinking about that, they still could have brought the due on sale clause. We're not saying here the due on sale clause is invalid. We're just saying that the friend is not on the hook because the express agreement that the carpenter would be on the hook, right? So this is, tough language, but they agreed that they would not expressly assume it, so they would not be personally liable. So let's just read this real quick. A mortgage is security interest in real property held by a lender security for debt, usually a loan of money. A mortgage in itself is not a debt, it's the lender's security for a debt. Is a transfer of an interest in land from the owner to the mortgage lender on the condition that the interest will be returned to the owner when the terms of the mortgage have been satisfied or performed. In other words, the mortgage is security for the loan that the lender makes to the borrower. The mortgagor of a property is generally free to transfer title to that property, but the mortgagor remains personally liable on the mortgage, and all subsequent grantees take the property subject to the mortgage. Subsequent grantees do not become personally liable on the mortgage unless they explicitly assume the mortgage. In sum, the mortgagor will always be personally liable on the mortgage. Only subsequent grantees who expressly assume the mortgage will be personally liable on it, and all subsequent grantees, whether they assume the mortgage or not, can lose the property through foreclosure if the mortgage is not paid. Privy of estate arises when the parties share a relationship with the land like a landlord and a tenant. So it is correct. The facts state that the carpenter and the friend expressly agreed that the friend would not assume and agree to pay the carpenter's debt to the bank. The friend thus did not assume the mortgage, which means she has no personal liability to the bank with regard to the mortgage payments. Although she voluntarily made payments for a few months, she was under no contractual obligation to do so. And when the carpenter conveyed Goldacre to her friend without first obtaining written consent from the bank as required by the due on sale clause, this allowed the bank to demand immediate payment of the entire outstanding mortgage balance from the carpenter, not the friend. However, the friend may still lose the property because the bank has the right to foreclose on the mortgage if the payments are not made by anyone. That's why the friend would probably pay them as a surety, but they're not responsible for them. So C is incorrect. The call to question asks who judgment should be for in the suit by the bank against the friend, not the carpenter. The bank may have an immediate demand against the carpenter for the full amount of the mortgage balance for violating the due on sale clause, But the issue presented is where the bank can recover from the friend. As explained above, the bank may not hold a friend liable because she not assumed the mortgage and her rights are unaffected by the due on sale clause. Tough question. All right. So another real property one. I guess this is a sign, right? The universe winking at us. Let's see. A woman owned Blackacre her home. Will the buyer win? Why would the buyer win? Okay. A woman owned Blackacre her home. Her daughter lived with her and always referred to Blackacre as my property. 2 years ago, the daughter, for valuable consideration, executed and delivered to the boyfriend an instrument in the property form of a warranty deed purporting to convey Blackacre to the boyfriend fee simple, reserving to herself an estate for 2 years in Blackacre. The boyfriend promptly recorded the deed. 1 year ago, the woman died and by will, duly made to probate, left her entire estate to the daughter. Okay? So the daughter had already conveyed it before she inherited it, and then the daughter inherited it. 1 month ago, the daughter, for valuable consideration, executed and delivered a buyer to an instrument in proper form of warranty deed, purporting to convey Blackacre to the buyer, who properly recorded the deed. The daughter was in possession of Blackacre, and the buyer had no actual knowledge of the deed to the boyfriend. Immediately thereafter, the daughter gave possession to the buyer. The recording act of jurisdiction provides no conveyance or mortgage of real property shall be good against subsequent purchaser for value without notice. So again, pure notice jurisdiction, unless the same be recorded according to law. Last week, the daughter fled the jurisdiction, of course. Upon learning the facts, the buyer brought an appropriate action against the boyfriend to quiet title to Blackacre. So we have buyer versus boyfriend. Boyfriend received it, and boyfriend promptly and properly recorded the deed, right? And then it was recorded to, it was conveyed to buyer, and then buyer, who had no actual knowledge of the deed to the boyfriend, he recorded. So if the buyer wins, so why would the buyer win? The daughter had nothing to convey to the boyfriend 2 years ago. The daughter's deed to the boyfriend was not to take effect until after the daughter's deed to the buyer. The buyer was first in possession, or the daughter's deed to the boyfriend was not in the buyer's chain of title. This is a wild question right here, because as I read it, I'm like, wait a minute. The boyfriend's gonna win, right? The boyfriend got it, stop by deed. So even though the daughter didn't have the right to convey it, it should have still gone to the boyfriend. And the boyfriend did nothing wrong. Homie recorded it, right? And it's a pure notice jurisdiction. So I don't care if they didn't have actual notice, they had constructive notice, right? So the boyfriend wins here, right? But they're not asking why the boyfriend would win. They're saying, why would the buyer win? Well, there's only one way the buyer could potentially win. If somehow magically, in this magical realm of magicalness, when boyfriend recorded, it was outside the chain of title, so buyer didn't literally have constructive notice. Because if he had notice, he's not a BFP. He didn't have actual notice. I'm saying he had constructive notice because it was recorded. But they're saying there's a possibility here. D's the best answer. If D were true, then yeah, that's why the buyer would win. But that wouldn't be true, and the buyer would never win. But if it were true, then they would win. I mean, why would you record a deed improperly outside the chain of title when, you just have to record it? It's not like a crazy thing to do, unless he didn't have an agent or an attorney or no one to help him. Yeah, so it's a pure notice jurisdiction. The BFP will win, and they can have actual constructive or inquiry notice. And here they didn't have inquiry notice because the boyfriend wasn't living there. They didn't have actual notice, but we assume they have constructive notice because it was recorded. That's why this is a crazy question, saying that the only way they would prevail is if they didn't have constructive notice because it wasn't recorded properly. It was recorded outside the chain of title. If that question tripped you up, it's a pretty weird question. All right, let's do another. All right. As the defense motion to suppress, the court should do what? A grand jury indicted the defendant on the charge of arson, and a valid warrant was issued for arrest. A police officer arrested the defendant and informed her of what the warrant stated. However, hoping that the defendant might say something incriminating, he did not give her Miranda warnings. He placed her in the back seat of his patrol car and was driving to a police station when she said, "Look, I didn't mean to burn the building. It was an accident. I just burned some papers in a wastebasket." At the station, after we gave Miranda warnings, the defendant stated that she wished to remain silent and made no other statements. The defendant moved to suppress the use of her statement to the police officer's evidence on 2 grounds. First, that the statement was acquired without giving Miranda warnings, and second, that the police officer had deliberately elicited her incriminating statement after she was in custody. As to the motion, defense motion to suppress, the court should deny the motion, grant the motion based on the first ground, grant the motion based on the second ground, or grant the motion on either ground. Majority of students are picking A. I mean, that was my instinct. Ashley, you'd agree with A here because it wasn't coerced and he didn't ask any questions. There was no custodial interrogation. Broski just ratted on himself. He did what people do, man. People suck. People don't have what it takes. Don't ever, ever, ever tell the police officer anything, right? Please don't be weak-minded. Not when you're in the back of the paddy wagon or not when you're taking the bar exam. Strong minds will prevail, right? So A is correct. Neither ground is sufficient basis for granting the motion. Miranda warnings were not required because no custodial interrogation occurred, and by hoping for her to confess does not amount to the police officer deliberately eliciting incriminating statements. It amounts to good police work. Hey, I got this freaking anxious, scaredy cat. I'll just put her in the back seat and she'll squeal like a pig, right? Sure enough, squealer's gonna squeal, right? It's only Miranda if they're doing a custodial interrogation, not if they're voluntarily making the statements, right? Even that she hoped for her to confess. That's good police work, right? Miranda is for custodial interrogations, not for voluntary squealing. All right. Oh, one of my students who was on a perfect streak, it ended on that one. Can you text me what you thought? I want to know. Okay. I thought the squealer one was kind of easy, honestly. So a plaintiff sued defendant for shooting her husband from ambush. The plaintiff offers to testify. Oh, this is a tough question. I don't love this question. The plaintiff offers to testify that the day before her husband was killed, he described to her a chance meeting with the defendant on the street in which the defendant said, "I'm going to blow your head off one of these days." The plaintiff's testimony concerning her husband's statement is admissible to show the defendant's state of mind, admissible because the defendant's statement is that of a party opponent, inadmissible because of improper evidence of a prior bad act, inadmissible because it's hearsay not within any exception. This question, I'm glad to see that you guys are picking answers. I just can remember the first time I ever did this question, I think I got it wrong. And I was like, really? But I think I know what the answer is. So, like, you know what I mean? I'll let you guys discuss it. Everyone's between A and D, a couple B's, but what are y'all thinking here? This is one of the questions I think I just memorized what the answer is. I don't really have the strongest argument for why.
I picked D thinking like it's not really a state of mind because he said one of these days. Like it feels very vague.
That's probably the best reasoning. That's the best reasoning I've ever heard. Let's go with D. I know it's D. I know it's hearsay, but yeah, one of these days, I guess, is not good enough. Let's read this
Well,
one.
I
'Cause
think the other part of it is that the defendant told the husband that, and then the husband relayed it to the wife. Like the wife didn't hear it herself either.
it's double hearsay. That's solid too. It's hearsay within hearsay. Great. The deceased statement to the plaintiff and the defendant told him that the defendant was going to blow himself one of these days is an out-of-court statement being offered for the truth of the matter asserted. The defendant threatened the deceased. Statement says hearsay is admissible because not meet the requirements for an exception to the hearsay rule. The brief explanation is not the best. Let's go to the extended. The FRE defines hearsay as out-of-court statement asserted. Statement that contains hearsay within hearsay. We need both statements to come in. So D is correct. The plaintiff's proffered testimony contains multiple out-of-court statements. These, I think, are amongst the hardest questions on the test, are hearsay within hearsay. The deceased statement that he had chance meeting with the defendant on the street in which the defendant threatened him, and the statement by the defendant to the deceased, "I'm going to blow your head off one of these days." Multiple hearsay requires that each statement meets own exception to the rule. Here it is true that the defendant's statement to the deceased may be admissible to establish the defendant's state of mind. So they weren't so caught up on that part that it was one of these days. So I guess it's still state of mind potentially. However, there's these statements to the plaintiff that defend him told him that the defendant was going to blow the deceased head off one of these days is an out-of-court statement that's being offered the truth of the matter asserted, that the defendant threatened the deceased. The statement is thus hearsay and inadmissible because it does not meet the requirements for any exceptions to the hearsay rule. Can you go back to the question? I want to see the defendant and the deceased in the statement. I want to see these double statements because it's such a short question. I'm like, how is there hearsay within hearsay? It's like only 5 words written. So a plaintiff sued defendant for hooting or ambush. The plaintiff testifies. The plaintiff is going to say that the husband's okay. They made it hard. The day before her husband was killed, he described to her in which the defendant said. So it's a he said, she said. The husband is saying what the defendant said. It's not she saying what the defendant said. That makes it double hearsay. Really great job, Alex. That's the reason why it's hearsay within hearsay. It's what the husband said the defendant said. The plaintiff saying what the husband said that the defendant said, instead of the plaintiff saying what the defendant said, which would make it potentially subject to some debate about one of these days, right? Okay. Or, party opponent admission. Oh, nice. That's the last question. Good job, Alex. All right, let's stop this. I'll take over share screen. What I'm gonna do is go over the cram guide that we made in class, this administration, and I'm gonna go over the last few sessions we had where we only did all subjects. So this will be quick and easy, and then I'll show off any albums that have been submitted, and that'll be the end of the July 2025 administration. I still have three students I have to do one-on-one sessions with. And also we are doing a proctored exam today from 4 to 7, as we've been doing, just because, we're not going to change the script. We're not going to change the formula. We're going to stay focused until the end. So we will be doing a proctored exam from 4 to 7, but this is the one thing I will say. Don't take some ridiculously hard exam that you're scared you might not go well. I would rather you do something like we did today. Do 100 questions that you've already seen before, so you just get a confidence score and you reinforce. The last thing I want you to do is take a test from 4 to 7, shake your confidence, have a mental breakdown, or as we call it, a mentee B, and go off on some frolic into the woods, right? I want you, if you're gonna be like, it would be nice to just do one more 100-question test and feel good, come 4 to 7 and do either a test you've already done before, or like adaptable review world or something, and just do another set of questions, 100 questions, to make you feel confident. It's a confidence builder tonight, so if you come to build confidence. And then what I'll share with y'all right now is the cram guide, like I said, and cram guides are the key to this. People say, what should I be doing down the stretch? If you're taking the MBE, you should be doing cram guides. Cram guides more than anything, because that's where you get your bread and butter, right? That's where you're cramming the correct answers into your mind. So it's been a really great course. I really enjoyed y'all. You guys have been super polite and friendly and respectful. And I think you guys have also been sharp in terms of mastering the material. So it's been a pleasure. But we have been creating since day one this cram guide for July. This is the master cram guide I've created over the years. This is the one that we've made in class together. So it's really nice if you can go over all these points we made. Some really great points here. But what I'm going to do is go right to the end where we did all subjects. All right, you guys ready to lock in? And then I'll do that album presentation and we'll call it administration. And then you guys will go and dominate this test, right? Like Brian Timms did upon making it to the NFL. You're going to have that controlled aggression. I like that. All right, all
Let's
subjects.
do it.
Let's do it. Yeah. All right, Linda. Yeah, let's fucking go. Top right corner. In a pure comparative fault jurisdiction, a plaintiff may recover the total amount from the defendant minus any percentage of liability attributed to him, right? And we're going to assume that on the MBE, pure comparative fault. The psychiatrist-patient privilege covers communication made in the course of treatment or diagnosis, but would not protect a statement to a nurse that he planned to shoot the president when she came to town, right? That's not going to be protected because of the implications of committing a crime. A bona fide purchaser is someone who takes for value in good faith and without notice. In the majority of jurisdictions, and to be assumed unless the language of the recording statute explicitly states otherwise, a judgment creditor is not a BFP, right? If the jurisdiction expressly protects judgment creditors, then a judgment creditor without notice will prevail just as a BFP would, right? Reading comprehension, reading the statutes. We've been reinforcing this a lot today down the stretch, so I think that's a sign. You might get a good amount of these, or a few of these, recording statute questions, and hopefully you'll be confident in how to navigate them. If the jurisdiction expressly protects judgment creditors, then judgment creditor without notice will prevail just as a BFP would. If a statute allows for a judgment to operate on a lien against real property, then owed by the defendant or subsequently acquired, this judgment will not apply to properties that were conveyed before the judgment was rendered, right? So again, reading comprehension, we did a question where it's like real property then owned at the time of the judgment, not property that was previously owned and then sold. It was a really tough reading comprehension question that we started off with. If an owner conveys a life estate and dies, the ownership rights revert back. If another party then charges a tenant rent and collects for the statutory period for adverse possession, he would prevail as a new owner because the tenant's hostile use of the property would be attributable to the new landlord. So if there's an adverse possession situation, there's a landlord-tenant, it's the landlord who's adversely possessing, not the tenant, because the tenant's adverse possession would be attributable to the landlord. While most gift promises are not enforceable, and this is the question I always think of when I'm like, oh, D's the best answer. Make sure you read A, B, C, and D, because D says, no, gift promises are not enforceable unless, right, a theory of reliance if it's necessary to prevent injustice. So you will enforce a gift promise only if it's to prevent injustice. Otherwise, you need consideration. A party may plead the fifth, the right against self-incrimination in a civil or criminal case. In a civil case, an adverse presumption may be made by the jury as a result. No presumptions based on the use of the right against self-incrimination may be made in criminal court. So you can plead the fifth in civil or criminal. Presumptions can only be made in civil. Once a clear repudiation has been made, the non-repudiating party is not privileged to buy additional materials. For example, if A and B agree to a construction job and A expects $3,000 profit and B repudiates, and then A goes and buys $5,000 worth of material for the job, right? After the repudiation, A's damages will be limited to $3,000 of expectation damages, the expected profit, because it was not in good faith or reasonable to buy the additional materials after the repudiation. A person of unusual sensitivities will be precluded from recovery in a private nuisance claim. For example, old people who like to nap during the day cannot recover against their neighbors whose children play loudly in the pool during the daytime, right? Look for that answer, unusual sensitivities preventing a nuisance claim from prevailing. If a state law requires that any person found guilty of misprescribing drugs shall lose their medical license, a man who is found guilty in court for misprescribing drugs does not deserve a notice hearing with the medical board because all the adjudicated facts necessary to result in his license revocation were fulfilled at the trial. If one party sends a contract to another and the other party sends back an identical contract omitting one term, this is likely concealment and the fraudulent party will not be protected by their actions. Look to punish the fraudster or the concealer on the bar exam. The contracts clause only applies to existing contracts. A woman who wants to be a ski instructor but has to take a course, pass a test, and pay a fee does not have a claim under the contracts clause because though her right to contract with the state is being impaired, she does not have an existing contract and therefore cannot make a claim under the contracts clause. There has to be an existing contract for there to be an impairment of contracts claim. If an employee of a company that is a party to a case makes a statement, I'm sorry for what I did, this statement can be used against the company as a party opponent agent, right? A party opponent admission against the agent of the party opponent. A witness who is testifying on behalf of a party's reputation for honesty can properly be asked if they have ever heard that the party was disciplined for cheating in medical school because it's relevant to the credibility of the witness. The best evidence rule applies to writings, recordings, and photographs, not models of robots, for example. A motion to transfer is more likely to be granted than a motion to dismiss for form nonconvenience. For example, if the answer choices are between form nonconvenience and transfer, and the location of contemplated transfer is proper, this is the more likely option to get approved for litigating elsewhere, right? Form nonconvenience means a dismissal and a refiling. A motion to transfer is easier to accomplish in practice. Knowing concealment can constitute fraud. If a person contracts for a job and the other party repudiates, the non-breaching party has a duty to mitigate. For example, if a teacher is offered $50,000 and then the school repudiates, her damages are $50,000, unless there's another job available as a teacher or she takes another job. In either of those cases, her damages will be $50,000, the new salary. She does not have to take the teacher job, but she can only recover the differences in salaries. She does not have to take the other job, but if she does, her damages are limited to the differences in salary, right? So if you, for example, if a teacher's offered $50K and then the school repudiates, her damages are $50K, unless there's another job available as a teacher or she takes another job, right? In either of those cases, her damages will be $50K minus the new salary. So I was trying to say not $50K, the new salary, but $50K minus the new salary, right? Because if you get a new salary, you can't be doubly enriched. So if there's another comparable job and it's the same, you can only take the difference between those salaries. If there's another non-comparable job and it's not the same, you're entitled to your total amount of damages, unless you actually take that job. Because if you take that job, you can only get the difference because then you'd be doubly enriched. So just remember that you have to mitigate and you cannot be doubly enriched. If a person but you don't have to mitigate if it's not the same job. Then you can just be regularly enriched and sit on the couch. That's the best scenario, right? I was talking with a student this morning how like the best case scenario is when you're a coach of like a football team and then you get fired for doing a bad job, but then they give you this monstrous buyout clause. So you just get paid all this money to not work. Like, I'm trying to curate that type of energy in my life. I need a monster buyout clause. I'd be happy to not work, right? If a buyer and a seller agree to a $10 widget sales price and it costs the seller $8 per widget to manufacture and the buyer repudiates and the seller finds a salvage buyer for $2 per widget, the total damages are $8 per widget because this is the correct measure of expectation damages. It's not what it costs to produce, it's what you were going to sell it at. That's your expectation. And as you guys have heard me say millions of times, I'm going to get out of the test prep business and get into the salvage industry because now all this person needs to do is be patient and find a buyer up in the 8 to 10 range. They're going to make hella money. And they didn't have to produce anything. Putting a foot in the window still constitutes entry for the sake of burglary. Therefore, if Susie puts her foot through the window with the intent to steal a necklace, but the dog started barking, she'll still be found guilty of burglary because the foot went through the window with the intent to commit a crime therein. Judicial notice may be taken at any time in the proceeding, even on appeal. The First and 14th Amendment do not deprive an entertainer the value of their commercial activity. An entertainer has a right to publicity, which means they can prohibit people from taking pictures inside the venue and broadcasting it. Conspiracy at common law requires a bilateral agreement, so you cannot conspire with someone who actually is planning to turn you into the police. However, the person with the guilty mind can be convicted of solicitation. An oral rescission of a land sale is valid. For instance, if two parties orally agree to rescind a land sale and one of the parties agrees to sell the land to a new party, this was a valid reliance on an oral rescission of the land sale contract. Unless specified that an offer can be accepted by performance, it can be accepted expressly or by beginning performance. And if accepted by beginning performance, the offeree must notify the offerer within a reasonable time that she has accepted by beginning performance, right? If you're performing, you gotta let them know that you're performing, right? Failure to correct a previous disclosure constitutes non-disclosure and therefore is a basis for fraud. Only defendants can remove. A defendant's counterclaim does not transform a plaintiff into a defendant for removal purposes. The forum state defendant rule applies when the original claim is based on diversity, not when there's a federal question. A dentist is a user for the purposes of strict liability, not a manufacturer, retailer, producer, distributor, supplier, and therefore cannot be held liable for strict liability for a faulty hypodermic needle. Furthermore, a dentist who uses due care cannot be found liable for malpractice because they haven't breached any duty. In a pure comparative fault jurisdiction, contribution will be a basis for reduction liability, but not a bar to recovery. A stronger argument is that no duty was breached because a child should have understood the risks associated, right? If it's a bright 12-year-old kid, that kid can read. Delivery occurs when there's present intent to transfer and acceptance. There's no need to be recording to establish delivery, right? So recording, yeah, it means there's been delivery, but you don't need a recording to have delivery. Delivery occurs before recording if there's been transfer and acceptance. If you have a reasonable basis for shooting someone, adequate provocation to shoot a man, and you shoot his twin brother, reasonably believing it's the right person, the instruction for voluntary manslaughter is proper. A variance is when a party is permitted to do something different than zoned for. A non-conforming use is when someone is grandfathered in to do something after the zoning laws change as they were doing it before. And amortization is conforming a non-conforming use over time. A seller of a defective lighter can be held strictly liable if the lighter explodes in someone's pocket. A third-party complaint that brings in a new defendant does not give the new party the ability to remove. Only the original defendants can remove, not those that are brought in via third-party practice. Procedural due process requires notice, pre-termination hearing, and post-termination evidentiary hearing. Under full faith and credit clause, one state must honor the judgments of another state so long as there was jurisdiction, judgment on the merits, and a final judgment. The crime fraud exception to the attorney-client privilege rule is an objective standard, not a subjective one. It does not matter whether or not the attorney knew of the legal purpose behind the communication. So whether they knew or not, if the communications were for an illegal purpose, the crime fraud exception will allow the attorney, to disclose the communications. The best evidence rule does not apply to robots, right? Recordings, documents, x-rays, things like that. Parole evidence is admissible to clarify an ambiguous term, to show custom trader usage, defect information, condition to contract, additional term, but not to conflict the terms of the contract. Restraints on alienation are void as a matter of law. For example, if A conveys property to B, but there's a condition that B cannot sell the property for 10 years, this is an invalid restraint on alienation and precludes the property from being marketable. A jury may not bring a learned treatise into the jury room because of the risk of reading non-germane parts. It may only be read by counsel or an expert witness to the jury. If a defendant is sued by two different plaintiffs and the facts show that they have separate unrelated injuries, the proper motion to file is a motion to sever and order the plaintiffs to bring different lawsuits. The Supreme Court has ruled that a party that could be found jointly and severally liable is not a required party. For the sake of issue preclusion, successive landowners are said to be in privity with each other. Therefore, a subsequent landowner can assert issue preclusion in the same capacity as a prior landowner, regardless if the question mentions mutual or non-mutual issue preclusion, because they're in privity and essentially the same parties. Privy for claim preclusion can be employer-employee relationship. So privy for issue preclusion, usually a subsequent landowner. Privy for claim preclusion is like employer-employee relationship, like the company and the truck driver for the company. A special verdict is an indicator of issue preclusion because it shows that the issue is actually litigated. If A conveys a life estate to B and then A dies and leaves the property to C for life and then D, the death of A will not strip B of B's life estate. When B dies, the property will go to C for life and then to D. So here it was A for the life of B, a life estate por ultra V, and A life estate to B for the life of D, right? So just because A dies, the conveyor, B still retains their life estate until the death of D, and then it goes to C. If a defendant fails to respond to waiver of service request, the plaintiff must actually serve them to effectuate proper service or process, right? Just because you send someone a waiver doesn't mean that you serve them. If they don't respond to it, then you have to actually serve them. PJ based on minimum contacts is a two-part test. It must first comport with due process in the state's long-arm statute. For example, the Supreme Court rules that a single sale is enough to establish minimum contacts, but the state long-arm statute does not permit PJ based off a single sale, then there would be no PJ in federal court in a diversity case because there's no basis under the long-arm statute, where it has to comport with due process in the long-arm statute before anything else. If a defendant opens the door by having a witness testify to the honesty of the defendant, the prosecution may rebut with specific instances. For example, asking the witness if he had ever heard that the defendant was arrested for embezzlement 2 years ago, right? Well, yeah, you're testifying about his honesty, and now we're saying, have you heard of his embezzlement? Well, if you've heard of his embezzlement, then you're not really being honest. And if you haven't heard, then you don't really have a good understanding of his reputation. Whether a presumption applies, such as who died first in an accident, is determined by state substantive law in a diversity case. That's the Erie-Claxon analysis, right? Erie means you apply the substantive law of the state where the federal court is sitting, and Claxon means you apply that state's choice of law. Those are only in diversity cases, not in federal question cases. In federal question cases, you apply federal, procedural, and substantive law. A forged release of a condition on a property in a recording is ineffective, right? We don't like the forgers. A lessor must warn a lessee of dangerous conditions on a property, including latent defects that the lessee would not be aware of. If a party moves for summary judgment and its affidavit shows there's no genuine dispute of material fact and it's undisputed, then summary judgment should be granted. If a person is sued for material breach of contract and they have an affirmative defense that they were a minor at the time of contract, this defense should be pled in an answer. It is not the basis for a 12b6 fair stated claim motion for dismissal because there is a claim. There's just an affirmative defense, right? Being a minor is not a 12b6 fair stated claim. There is a claim. There's just an affirmative defense that you're a minor. Voluntary motion to dismiss versus notice of dismissal. Both are ways to dismiss and refile. However, the notice of dismissal may only be made before the defendant answers or moves for summary judgment. After that, right, it would have to be a voluntary motion to dismiss. If a defendant played a video recording of a conversation he had with his attorney to his father to get his father's reactions, the tape would not be considered confidential as it was shared with a third party. It's more convenient to file a 12b motion to dismiss for lack of PJ than to file an answer with an affirmative defense of lack of PJ. For minimum contacts, there must be relatedness. For example, in a subsidiary that ends up with 2% of the tires could not be sued in America for an incident that occurred in Europe because the minimum contacts test had not been met, right? It wasn't the parent company, it was only a subsidiary, it was only 2%. That was a tough question, right? And then finally, in diversity cases, in accordance with federal law, and this is a really good point, the second court should apply the preclusive effect of the first state where the claim was filed. Remember, preclusion is actually a federal procedural issue, but common law, federal common law tells us to use the preclusive effect of the first court where the case was decided, right? Here it says where the claim was filed, but someone did come up with a really good scenario and say, what if it was transferred to another court and decided there? Well, that's where you'll have the preclusive effect. So example, if A sues B in federal court in state A under diversity, and the claim is involuntarily dismissed, and state A does not operate as adjudication on the merits, then the preclusive effect will be that this case can be refiled in state B, even if in state B, involuntary dismissals operate in adjudication of the merits. Why is that? Because we're not going to look at the new state where they're filing to determine the preclusive effect. We're going to look at the original court where they had the ruling to determine the preclusive effect, even in diversity cases. So you'll use the preclusive effect of the first court when determining claim or issue preclusion. So those were all the all subjects that we did, and then we've done every subject one by one, and then we have the Master Cram Guide. And what I'm going to do, and if anyone's watching this video, publicly, I'm going to add the July all the July notes that we took to the Master Cram Guide that we have available somewhere. But I have a Master Cram Guide available that I will be adding all those points to, and that that's available for purchase on the website for the smooth price of $50. Or if you see me in Tampa, I'll give you free access to it. Okay, and last but certainly not least, we're gonna end the administration by seeing if any of y'all have submitted your album covers, and this is what the people love the most. So let's see what we got here. Album cover assignments. Oh yeah, so there is a Master Cram Guide. It's right under all subjects. So right under the album covers, you can see the Master Cram Guide is available as well, right? So the Master Cram Guide is available right under the album covers, and here. All right, no one turned one in during class. That's good. You guys are all participating. All right, so we got Ray Sips with Loquitur. It's gonna be good. Ray Sips with Loquitur. It speaks for itself. So does Diddy. I guess. Are you here, Andres? I don't know if the creators. All right, you got any? Let's let the creator present. So what were you trying to teach us with this one?
I was trying to say like his baby oil kind of speaks for himself, that he kind of likes his little freak sauce and stuff like that. So I
Yeah,
try, implementing some
humor. Yeah,
stuff that's going on right now currently.
I heard he got away with it though, so I guess it wasn't enough. The baby oil didn't speak loudly, but yeah, Diddy, he speaks for himself in terms of freak offs, and Ray Sips Loquitur, the thing speaks for itself. So let's say the baby oil that caused the injury was under the exclusive control, or here's a better example. You won't forget this one. This is what you should have done. You should have taken the baby oil and left it up someone's, left it in their body, and then say it speaks for itself that Diddy had exclusive control of the baby oil. And in the absence of negligence, it doesn't end up in one of the freak off contestants' bodies. So therefore, under Ray Sips Loquitur, it was under exclusive control of the party, and it wouldn't have occurred in the absence of negligence. It speaks for itself. The diddler is diddling. All right, let's see what Caitlin O'Flanagan got. Okay, Joan Jett, bad reputation, impeachment through prior bad acts, prior inconsistent statements, prior convictions, and opinion bias sensory defects. So you don't know what you've got. All right, Caitlin, you want to give us a little insight on
Yeah.
this one?
I don't know. I didn't have a lot. I just was listening to a song the other day, and I was like, oh, that'd be good for my album cover, like impeachment through bad reputation, and then I added this other stuff. But yeah.
What's her band? Is she in-
Joan Jett.
Yeah. Wait, you said Queen of Jet? Oh,
No, Joan Jett is the singer.
oh yeah, she's a singer. Yeah, is she in a band or she was just by herself?
Oh, Joan Jett and the Blackhearts.
Joan Jett and the Blackhearts, yeah. Bad reputation. Okay. So yeah. So impeachment. You can impeach someone's bad reputation through prior bad acts, prior inconsistent statements, prior convictions, opinion bias, sensory defects, right? These are all ways that you can impeach someone. This is a solid cover. All right. And then I think we got Ashley. Are you with us, Ashley? Ash Cash, that's a solid name. Volume 3, the SCOTUS, Supreme Court of the United States. Can't touch this, unchangeable, leave me alone. Okay, the original jurisdiction of the Supreme Court, I like that. That's cool stuff. That is a fix, right? The original jurisdiction, you can't touch this, MC Hammer, right? But the appellate jurisdiction can be modified, abridged, or even eliminated. And she had to hit us with 2. She hit with a double album. Ash Cash, the new never single, necessary and proper, enumerated rights sold separately. She's not really here. I mean, the necessary and proper clause, I guess what she's trying to say is that it's not going to be a standalone answer. Necessary and proper is going to be combined with the Commerce Clause or with the Taxing and Spending Clause. So if you see this answer, necessary and proper, it's probably never going to be, yeah, new single, never single. I think I get it. It's about that it's not going to come alone. And I guess she's saying that she's never alone. She's had like 18 boyfriends in my lifetime. But now she's with Travis. All right, nice. This one we needed this one. This one's from Karina Scarfable. I always went with even a student can fake a laugh for ridiculous bar facts, but honestly, I don't see many laughs being faked, and these ridiculous bar facts aren't that funny. So we're gonna throw that one out. And now we're coming up with SIC Productions. She's got her dog in the front seat, Enzo, the Malinois. 2025 specific intent crimes productions, all rights reserved. All right, this is a really good one. Scarfable with 3 Fs. Solicitation, conspiracy, assault in the majority of jurisdictions, robbery, false pretenses, forgery, and first-degree murder, attempt, burglary, larceny, and embezzlement. So pretty much first-degree murder, the inchoate crimes, the fraud crimes, and the theft crimes. Those are the ones that are going to be specific intent. So I think that might be all of them. I know Gabby. Oh yeah, I've already graded Gabby's. Gave her A+. Gabby, are you with us, Gabby? She might have stepped out. Or she might have been traveling today. All right. Does anyone know
Don't
this?
forget mine.
I'm not. Don't worry. We're saving the best for last, my boy. Does anyone know who this dude is? Because I have no idea. When she showed me this, I was like, I don't know.
Chrisley.
Yeah, I don't know who that is. I'm not gonna lie. I'm not that tapped into the Todd Chrisleys of the world. He looks just like the dude from the Coldplay concert who was hugging up on the HR lady. But anyway, the absolute power of president, the absolute power of the president. President can only pardon federal crimes. Yeah, the president pardoned this guy, I guess. So the president pardoned, he pardoned Lil Wayne, I remember. Biden pardoned, his son. Trump pardoned the January 6th group. So, there's a pardons that can occur. It's a federal power. You can't be pardoned for state crime. So maybe this dude will help you think of that. I have no idea who this guy is. He looks, do we like him or do we not? I don't know. Am I supposed to like this guy or not like this guy? Or I'm ambivalent. Okay, I'm ambivalent. And then last but absolutely not least, Luis. All right. So, oh, this is perfect, man. This is super fitting with Brian Timms, man. Brian Piccolo, Brian's song.
That's the back. That's the back cover, though.
At the back, let's see the front. All right, the front is the right to bear arms, exactly. By 10 yards offensive holding. So side A tracks are separation of powers, checks and balances, judicial review, necessary and proper, supremacy clause, due process, equal protection, eminent domain, suspect class, the Super Bowl shuffle, and the Perry push. Really solid stuff. I like that. The right to bear arms, Second Amendment, and these are some really important pieces for con law. So the artist, 10 yards offensive holding, and the album is the right to bear arms. Could be adverse possession too, he's saying. And then let's see the back. All right. Yeah, separation of powers and checks and balances, judicial review.
That's McMahon and Walter Payton.
Walter Payton, yeah. I thought this was Gail Sayers and Brian Piccolo, but I knew that was Walter Payton. Then I started questioning my entire existence. But yeah, Walter Payton.
Jim McMahon.
Yeah, and his kid used to play for the Hurricanes, Walter Payton Jr. All right, cool. That seems to be the album covers. I think this was amazing. I think we had a really great administration. It's cool that we started and ended with football today because it reminds me that football season is coming up, and once this bar exam is finished, I'll be locked into the season, right? In Florida, we say there's fishing season and there's football season, but for me, it's been bar prep season for the past few months. I've been really grateful to work with each and every one of you. I've never been more confident in my students going into test day, especially with the MBE. I think this is the administration where I put the most effort into MBE and mastery, and I'm really looking forward to hearing about your passing scores when they come out. But you have time. It's Sunday afternoon. The MBE is on Wednesday. Maybe you have a test on Tuesday until then, but I would spend the rest of the day, going over cram guides, doing light study, trying to focus on making the things concrete, learning what cold. Don't focus on uncertainties, try to solidify certainties. Right now, we're really trying to embody the spirit animal, the shark, right? So the shark lives in cold water. You know, the shark is cold-blooded. I want you to learn the material code, and then I want you to go out there and murder that test, just like sharks are, you know, the apex predators of the ocean. Y'all are really the apex predators on this exam. Like I said over and over and over again, it's such a privilege and honor for me to be able to work with each and every one of you. And, you know, like Kobe said, the job's not finished, and that goes past the exam. Once you get your results out, you know, stay in touch with me. I might have opportunities if you're interested in helping other students pass the bar exam. And I know every attorney in South Florida, right? So I could probably help you advance in your career. But I really care about you, and so does my staff. Reach out to us, and don't be a stranger. If you're gonna be taking a Florida bar exam, I'll be in Tampa. I'll have hella merch and things. So try to find me and say what's up. And then Wednesday night, I'll be at American Social with my team, cheersing to another great administration. So thank you all so much. I wish you all the best of luck on test day. I have the utmost confidence in each and every one of you.